days, it's not all about the product supplier. It's not all about the products per se. And that's similar to the 4 hours and this 4 module. I mean, risk profiling and due diligence, and you that have enlisted for it or registered for it, it's wonderful. And that's good signs to come for financial planning as a profession. So let's start off with risk profiling and due diligence. And I think it's just important before we start with risk profiling to understand the concept of risk profiling. What do we mean by the word risk profiling? Now, the first thing is that when I talk risk profiling, firstly, we talk about risk profiling for the client. But I'm also talking about risk profiling of the product that you will use for the client. And then thirdly, also talking about risk profiling of the product suppliers that you will be using. When you look, and I will get back later to the two FICE onboard determinations, and then you will see that some of these determinations is not all about did you establish the risk profiling, but also did you understand the product uh, and did you understand the company? And that's where the due diligence part comes in. So it's for me vital. So risk profiling. Why risk profiling? Risk profiling is for us really important to understand our clients better, to know our clients better. But what is the use of risk profiling if we only understand the client better? The real use of a proper, good risk profiling that will be dealt in module 3 and 4, especially by Peter and Marius Kilian, is the asset allocation that we can link to that. So just to start off, also the importance of risk profiling, then we will have to look at regulations in South Africa. And when we look at the General Code of Conduct and we look specifically at paragraph 2, one will, and I'll read to you, a provider must at all times render financial services honestly, fairly, with due skill, care, and diligence, and in the interest of clients and the integrity of the financial services industry. So that's a due diligence aspect there with due skill, care, diligence, and the interests of clients. And that what risk profiling enables us. It enables us to deliver financial services and specifically financial planning and investment planning with the necessary and due skills and also in the best interests of our clients. But then secondly, very important, and Peter, you've alluded to paragraph 8 of the General Code of Conduct. And paragraph 8 talks about suitability. And one will say, but why, Wessel, do we need to do a risk profile? One of the aspects, and when we look at paragraph 8(1)(b), it reads, conduct an analysis for purposes of the advice. Based on the information obtained, identify the financial product or products that will be appropriate to the client's risk profile and financial needs subject to the limitations imposed on the provider under the Act or any contractual arrangement. So there's where we find this word or this concept, the client's risk profile. And you will see they linked it with the financial product or products that will be appropriate. And that's how we get appropriateness of product. And that's how we get the right risk profile to start with doing a risk profile for our clients. Now, before we continue, and I think in module 2 or maybe module 3, Peter will highlight more on risk profiling and the different elements of risk profiling. But if I may, as an introduction, discuss the 3 legs of risk profiling. Then we talk about risk capacity. Now, what is risk capacity? It's the ability of you or your client to take a risk. So risk capacity. And a lot of people say, but Wessel, how do we establish risk capacity? Risk capacity is numbers. Risk capacity is a calculation, quantitative. So you need things like the age of your client. You need things like the income of your client. You need like the accumulated wealth of your client. So the picture at this stage. Things like the dependents can help. So that's the type of information that you will need from your clients to calculate the risk capacity or the ability to take risk. And I always explain to I'm currently uh, on a part-time. I love to teach young people and students. So I'm, for my sins, involved with the Universities of Stellenbosch's Business School with their postgraduate diploma in financial planning. And I always tell them when we talk risk capacity, I'll explain it simply as somebody that's got $1 million and the market drops with 20%. They will lose 200,000, so they will have 800,000 left. Somebody with 10 million, on the other hand, and the market drops with 20%, will have 8 million. So you can see the difference in those two people's capacity and the difference in taking up a risk of 20%. That's the first leg, is therefore the capacity, the risk capacity. Now let's look at the second leg, very closely related to risk capacity, and that's risk required. And this is also a financial characteristic. Now, risk required is, this is the funds that I've got, this is the accumulated wealth. So what do I need to get to my goal? So let's say you've calculated the retirement goal for your client already. You've got the amount already invested, and that amount must be sufficient, let's say, from retirement till date of death, whatever life expectancy you have. So it's also a calculation. And obviously, the less money saved, the higher the risk required, the higher return you need on your investment. Then the last one, risk tolerance. And this is where a lot of people confuse this conversation. A lot of people think risk profile equals risk tolerance. Now, your risk tolerance is your willingness to take risk. This is a psychological characteristics. So, and that's also where I think a lot of these risk profile questionnaires make a booby about this, is that a risk tolerance questionnaire will typically have psychological type of questions in. And that's why a good risk tolerance questionnaire must be drafted with the assistance of psychometricians. Otherwise, it will not be an effective measurement instrument. And we will get in when we go to the report, or the that we drafted in 2014, that Anton Swanepoel was the main author of, and that Peter referred to. I will come back to this particular point. So just to highlight again, risk profile has 3 legs. The first leg is risk capacity. The second leg, risk required. And then the third leg is risk tolerance, or your willingness to take any risk. Now, if we look at the slide in front of us, why is risk profiling so important? It's important, firstly, to know your client, as said, but also to make sure, as said in the paragraph 8.1 of the general code that I've read, that you can link the two to each other. That's the product or products with the client's risk profile. So if there's a mismatch, like we will see in the 2 FICE-OMBU determinations, there will be a problem. What is this objective? Risk profiling process will be typically to establish your client's needs, to establish their objectives and circumstances. So to know your client, but the most important, to know their goals and objectives. You cannot establish a client's risk profile properly if you do not know their goals and objectives. And then their capacity for loss, the risk required, the risk tolerance, 2 of those which you can calculate. The risk capacity, something you can calculate. The risk required is something you can calculate. And the risk tolerance is something that normally you do with a questionnaire, that was drafted with the assistance or involvement of psychometricians. And then you match these with each other, and that's how you get to a risk profile. And it leads you to a proper asset allocation, or hopefully a proper asset allocation. So when we look at observations, when I look at observations, when I read Vice-Ombudsman determinations, these are four of those that stand out. The first one, there's a disconnect between risk profiling. And as already mentioned, risk tolerance and risk profiling, or the other two legs of risk profiling, and actual circumstances. The two determinations that I will be dealing with you will clearly see that risk tolerance questionnaires were completed in both those determinations. But in both the determinations, the asset allocation were not linked to the risk profile, which in itself is a problem when there's a complaint laid against you. Secondly, risk profile questionnaires are questionable. I mean, numerous of these questionnaires that I've seen, they mix and match these risk capacity, risk tolerance, risk required, as if it's the same thing. And then you work with a point system, and at the end, you don't get to a scientific, correct answer that can help you to develop a proper asset allocation for that client. Thirdly, risk is not disclosed, and if disclosed, not in a clear and unambiguous language. That's one thing that I see in almost all the complaints. You know, that the respondent or the advisor or financial planner will discuss with their clients the risk, but not in detail, not linking to it. They're very vague about it. So this is the product, this is what they do, this is what the fact sheets say about the product, but they don't link that to the client. The client will say, but we're moderate or conservative. Let's say there's no risk profile, or there will be a risk profile. And then they will invest their clients in high equity and high risk assets and those type of investment instruments, which is a huge problem, not linking the two to each other. Then lastly, financial services providers and their representatives are being held accountable by the Vice-Ombudsman. That's more and more so. And I will also show you in one of the two determinations, I'm not sure whether the Vice-Ombudsman themselves always understand what the proper risk profile is and what's the different concepts. But I must say, I was not that involved with the compliance side of things the past 2 to 3 years, so that might have changed completely. Then the following point, when you're assessing suitability with regard to investment advice, is assessing financial needs and risk and linked to suitable investment and financial product decisions. Why is that important? Again, just to take you back to the General Code of Conduct and paragraph 8 that deals with suitability. And bear with me, I'm just quickly going to read 8.1 A, B, and C, just to give you context of assessing suitability with regard to investment advice. Now, paragraph 8.1 clearly stipulates a provider other than a direct marketer must, prior to providing a client with advice, take reasonable steps to seek from the client appropriate and available information regarding the client's financial situation. So what must we do? Get sufficient information so that we can do a proper analysis, give proper advice, and so that the client can be properly informed about the decision they should make. Then secondly, the financial product experience and objectives to enable the provider to provide the client with appropriate advice. That's something that I don't see regularly from financial advisors, that they establish the financial product experience. And that can be a thing that saves you. If your record of advice submitted after a complaint, that you did a proper almost a product experience analysis, and you can say, but this client was qualified, they manage their own share portfolio or what have you, and they've got a high level of knowledge or product experience. That can save one. And then also their goals and objectives. But when we move further, then we need to conduct an analysis for purposes of advice based on the information obtained, and then identify the financial product or products that will appropriate to the client's risk profile, as already said. You know what came to mind when I thought and when I went through preparation for this presentation is a lot of time we do single need advice. And I thought by myself, when you do a risk profile for a client and it single needs advice on a particular investment, so you deal maybe with 2 million of that client, but the rest of the portfolio, the rest of the assets, the risk management and the estate planning is maybe not with your company and your financial advice firm, then it's very difficult sometimes to establish the risk capacity of that client. So it's important to get sufficient information that you can establish this framework and that you can quantify the risk investors are willing and able to make. And listen to your clients. Again, referring to the determinations, when we look at that, both of those, the clients were people close to retirement, already in retirement. They said, we don't want to take a lot of risk. Now, I mean, it's a lot of risk taking by you if you then go and advise the clients to invest in a product that takes a lot of risk. Now, let's move to this document that I mentioned, assessing suitability with regard to investment advice. And that's the document drafted in 2014 that Peter also referred to. And I'm just going to cover one or two, maybe more points on this document, but I invite you. The document was made available. Go read through that document. Like I've said, Anton Swanepoel was the main author of this document, and this can be very, very good source of making sure that you deal properly with your risk profiling, and also the start to a proper due diligence process that Peter will highlight in the second or the third module that he will be dealing with. So the table of contents, it deals with introduction, concerns raised by the Vice Ombudsman, and I will look at some of those concerns, international research. I will look at just the highlights of that, and then the industry dilemma of risk profiling, common flaws, the fundamentals, and I will highlight one or two of those, and then the role of product suppliers, a proposed plan action by all the stakeholders. That, in a nutshell, is this document called Assessing Suitability with Regard to Investment Advice. Now, let's move on to the document itself. And in this document, when we look at the introduction to the document, then we will see it deals mainly with things like the defining and quantifying of risk tolerance. And I will just like to highlight, the importance of linking the risk profile back to our legislation. That's why we're talking today about this. Not only because you want to be not in trouble, but because legislation tells us, with the introduction of the Financial Advisory Services Act, the FICE Act, and its subordinate measures like the General Code of Conduct in 2004. This have highlighted a number of important issues pertaining to investment advice in particular, with which the financial services industry and we all listening in, that we're struggling with. So it's important, and those things are, like we've highlighted on the slide, defining and quantifying goals, needs, and objectives clearly. I'm currently the MD of a financial planning company, a small financial planning company that we try to do things right. But what I'm struggling with our youngsters particularly is this first one sometimes. When they have this early conversation, or the first conversation with their clients, is to establish those goals and needs and objectives clearly of those clients. And as we've seen from the General Code of Conduct, it's crucial. You cannot give suitable advice. You cannot do a proper risk profile if you do not know what the goals, needs, and objectives is of your client. That's the starting point. And then also quantifying risk in the context of providing investment advice, risk required to take in order to achieve the goals, needs, and objectives. Because at the end, we know we need to establish where the client currently is. If we clearly establish the goals and objectives with this client, we know where they want to be. And now with the risk profile, the risk capacity, the risk required, the risk tolerance, that helps us now to identify this gap and the risk towards this gap and what type of asset allocation we need to advise on for this particular client. So another big point that we're struggling in the industry is disclosures. I cannot tell you. Go and read these determinations. Almost every second of these determinations talks about not this was not disclosed. This was not in the record of advice. And that's so important. And especially when it pertains to risk. Clients or the complainants will always say, but they did not discuss the risk of this product. I did not know this was such a high risk product. And that's why it's very important for us. I said in the beginning, risk profiling and add to that due diligence is not only for our clients, but we must do that also in the products we advise on. Do you know your product? If you just read through the fund fact sheet and you don't understand how that product works, whether it's licensed, those you setting up yourself for failure, even if you did the risk profile of your client. So it's also important to establish the risk of that product and don't to fall for the nice marketing brochures that some of these companies do send to us, and you will fall and you will not properly advise your client and not give suitable advice. So all at the end, providing suitable advice, ensure the advice is understandable and informed investment and financial product decisions can be made. And then recording of your advice. So disclosure is still a big problem. Even in my company, when I look at some of the financial advisors and the way this goes, disclose, we're very strict about that. That be upfront with your fees, be upfront with the risk of the product. Rather lose probably the client with proper disclosures, because what I've seen in practice actually that builds more trust. Then your record of advice. Make sure that in your record of advice, you clearly stated the risk profiling measures you did and how you got to suitability. And never ever forget, if you replace an investment product, that what is needed of yourself. When you go to paragraph 8(1)(d) of the General Code of Conduct, it tells you precisely what you must have in your record of advice and what you must disclose to the client when you replace a product. And sometimes we forget about these type of things and what to inform our clients on. Then to end off this, before we turn to the next slide, is without a proper understanding of customers' risk profile and an understanding of the risk profile of proposed investment fund or portfolio, no advisor, not you, not me, would be in a position to give suitable advice. And no customer or client would be in a position to make an informed investment decision. So this means that in order to give suitable advice, we must fully understand the needs and risk profile of the customer, and as well as the risk profile of the proposed investment product. So keep that in mind. So let's move then on to the following slide, and let me see here the concerns raised by the by the FICE language and these investment terminology, and we will bombard them with risk profiling and the technical stuff and to show our knowledge. But the problem is sometimes our language that we use is not simple. It's not clear and unambiguous. And that makes it difficult for our clients to understand. The past month, I had 3 clients that said, Wessel, your report is simple to read and we understand the what you're telling us. It's in our language. And I think it's something we can learn, even when we connect the dots with risk profiling and what we're doing with these things. All right, let's move on to the international research capacity. And on page 5 of this document, you will see that the concept of risk and the application of risk profiling questionnaires is not a South African problem, like Peter alluded to. And it's so important. The Financial Services Authority in England in 2011-2012, they said in a report on assessing the suitability, establishing the risk a customer is willing and able to take, making a suitable investment selection. They said half of the files assessed between 2008 and 2010, that's now in the UK, were unsuitable on the grounds that the investment selection failed to meet the risk of the customer. They talk about customer and was willing and able to take. And I see the same thing happening in South Africa. I see the same thing when I read through these FICE onboard determination, when I read through the questionnaires that's there in the market. So we must be really careful what we supply to our clients or customers. The other thing that was highlighted in this risk profiling white paper is, what is the common objective? I mean, the common objective of legislation and of the Financial Services Conduct Authority is consumer protection. You will agree with me. So that's why we've got something called FICE, the Financial Advisory Intermediary Services Act. That's why we've got TCF, treating customers fairly. That's why they started with the RDR, is to protect clients. Now, sometimes you say, but Wessel, all these compliance and this risk profile questionnaire, and I make sure suitable and I need to record these things. And what I say, it's just good business practice to do these things. It's not about compliance. Yes, it's about compliance for the regulator, but it's good just to make sure that the products and your advice are suitable to the client and the background of the client and the knowledge and the understanding. That's just pure good business, proper business solutions that you will give your client. And with that, you will also be complying. Another thing is, what I also see is that people say, I did not know. There's a couple of determinations that clearly highlights to us that say ignorance is no excuse. So the fact that you say, well, I don't know about risk profiling. I don't know what's a concept risk profile. I don't know how do I include risk profiling. And like I've said again, in module 2, 3, and 4, Peter will touch on how to do a risk tolerance, how to use your information of a risk profiling and then in the last module also to map that to your investments. So you will see in the later modules, we will get more practical in doing this. One of the key aspects that you and me, the advisor, the financial advisor and planner, is to educate our clients. You know, I take really sometimes 10 minutes, 15 minutes, just to sit with my clients to explain to them why are we doing a risk profile, what it is, how does it fit in, to explain the numbers so that they can get the surety I'm doing things in their best interest. And I want to make sure that whatever we recommend to them is at the end of the day suitable advice. Then the last thing, when we deal with the 3, it was the client or the customer, it's us, and then the product supplier. My question is, do the product suppliers come on board? How do they support us as financial planners or financial advisors to uh, give the best advice to our clients, and what we do to our when we advise our clients? And I mean, finding appropriate solutions for risk profiling problem will require a collective effort. Not individuals like me or Peter or you listening in. None of us can do a proper job. We need the support of the product suppliers. I just would like, Peter, if I may, I see, Peter, you've mentioned there are no clear and directly applicable precedents. You just have to make certain that the tools and processes that you use will stand up to the highest level of scrutiny. I agree with that, Peter, and thank you for answering the questions of the people. I will be covering the questions in great detail in the next module. Sorry for diverting, but I just saw Peter's note on that. Continuing then also with the advisor, the Vice Ombuds determination have already clearly demonstrated that ignorance is no excuse, as said. If financial services providers do not understand the fundamentals of suitability of advice, they will be held accountable, and so they have been. So providers will have to educate themselves with regard to investment risk and the appropriate application of risk profiling questionnaires, and that's why this becomes so important. So let's move on to the fundamentals. Risk should be clearly defined. And just to go back again, and before we move to the Vice Ombud determinations, clearly defining your investment risk is to first to establish your client's financial situation. It's important. In the introduction, I said to you that you cannot do a proper risk profile if you do not understand your client's financial situation. I mean, if it's a single need from your client and they just say, Wessel, I want to invest in a retirement annuity, and you do not know what is their financial situation, you do not know their age, you do not know whether they've got other investments, it gets really difficult to give suitable advice. Then also, if you do not know your client's product experience, uh, whether the client handles sometimes some of the investments themselves, do they understand what is a retirement annuity versus a unit trust versus an endowment? Do they know how these things work? You must be very careful, and that forms part of the risk of your client. When I look at risk profiling, and maybe let me just refer back, we're talking today risk profiling your client, but risk profiling your client to make a suitable to give suitable advice and to make sure the product advice and the advice that you give to them is suitable to their objectives and needs. But there's also, for me, a risk profile, making sure that client fits to your business. That client is not a risk of your business. That's something completely, and I'm going a little bit off the topic here, but risk profiling also, is it the right client for my business? And then also risk profiling of the product supplier you are using. I mean, you can just think about ShareMax. You can, and I will allude into one of the determinations about one of the unit trusts they've used there. Did you do a due diligence on the product? Did you do a risk diligence on the product supplier? And it amazes me sometimes the products people and the companies they invest, then they don't know what these companies and the risk. So there's also risk profiling and due diligence that covers the product supplier and then also the client suitability of your business. But the main focus today is the risk profiling of your client to make sure that your advice is suitable to the client. So risk profile, as referred to in the Vice General Code of Conduct, defined risk profile is the appropriate level of risk having regard to the investor's risk required risk capacity, and risk tolerance. And just to highlight, if you missed maybe when I explained risk capacity, risk capacity is data. It's something you can calculate. It's things where you need the annual income, you need something like the accumulated wealth of your client, you need something like the age of your client, job security, number of dependents. All those can help you to calculate the risk capacity. Can they take this risk? Then secondly, risk tolerance, your willingness to take risk. So it's your emotional, it's your psychological characteristics. So if the market goes down 10% or 20%, will you able to live with that? And then risk required, the risk that you need to take to get you to. And these must be used in a combination. You cannot use just one of these elements and say, now that's what this client's risk profile. And then you need to link it to a proper asset allocation to get to diversification that links to the client's risk profile. So it's important that investment managers align the risk profiles of their funds with the definition of risk profile as understood by investors. And I know, Peter, I think it's in the last module that Marius Kilian will go more in depth into aligning your investments and how to look at risk profiling and investments per se, and how do you link that with each other. What is remaining for us to discuss is the two vice ombud cases. And we've picked these two vice ombud cases because it clearly highlights to us the problem if we do not a proper risk profile. Or in most cases, they did a risk profile, but they did not link the client's knowledge, the client's information, the client's risk tolerance with this risk profile, and they did not link it with the investment advice. It's a mistake that I see regularly. And then if we jump back to what I've said earlier, then you don't get suitable advice. Then you get a disconnect between the risk profile. So yes, you've ticked all the boxes. You went through a risk profile. You've got the client is maybe moderate, but then you go and advise your client on a high risk investments or in high equity or what the case may be. So there must be a link through to all these things that aligns then at the end to the investment. So let's look at this first one, GF and EH Botha versus RNS Walsh investment. And it's again dealing, and just for the background, it's always interesting to see that the complainants in this determination, at the date of the determination, they were already 76 and 73 years old. 73 and 76 year old. When the advice was given, they were in their 60s. So the complaint was all about inappropriate advice, where they said, but it was not suitable for us. It was too aggressive and risky. I mean, they said to the vice ombud, but our investment were interest-bearing investments, and now we in high equity. I mean, the facts of this played off in 2007 and 2008. And we know what happened in 2008. And during that period, despite the risk profile or a risk questionnaire that the advisor did, and despite the fact that these people were living from the money, that they were in their 60s, retired, he switched them. And I'm not saying that's wrong. And maybe it's important. When my mom, she was a farmer, when she sold the farm at 67 and we had to make decisions on the investment, you know, sometimes you think 67, oh, you're retiring now, we must be moderate or more conservative. But then I realized, and I said to my mom, you know, your mother, my grandmother, She died at the age of 88. You're 67 now. That's 21 years if you should survive till the age of 88. So please, the one thing that I'm not saying is that age determines that you need to go conservative or what. That's why you need the risk profile. In this case, and let's get back to the case, they were switched to things like Allan Gray Equity, Nedbank Rainmaker, and then again in 2008. During the crisis, they were switching to things like Investec Commodity Fund, Investec Equity Fund, Investec Managed Fund. And at the end, the portfolio was almost completely equity-centric, if we can call it that. So it's opposite to the point also out that there's no the FICE Ombud could not find any records on the file. How did this advisor got to the reasons why he suggested that? So there was nothing on record that could show the suitability of the advice. So be very careful. The one thing is your client must be informed. So you need to give a record of advice or a document to that client that can inform the client. You need to educate that client, and especially if that client is not familiar with investments, is not familiar with investment products and the type of investment products that you recommend. And disclosure. You need to disclose your fees, but more importantly, also the risk of the products that you're advising. And you need to align that with your client's knowledge, with your client's risk profiling, with your client's financial situation. All this must play a role then in your decision on making sure it's suitable advice. Interesting that I've also picked up in this determination, and let me read to you where the FICE Ombud said it is pertinent to the point out that there is no evidence suggesting that complainant circumstances were considered. The FICE Ombud said in this determination, there was no evidence that the complainant circumstances were considered. So let me ask you, if there's a complaint against me or you, will there be sufficient evidence, sufficient record that can show to the FICE Ombud the circumstances? How did you went about to decide on these products? And did you do a risk profile? Did you explain to your client risk profiling? And how do you look at the client's knowledge, the background, and so forth, and also his wealth capacity? So this flows from the fact that there was no document that the FICE Ombud could find. And the master said that before going any further, advice furnished to a client must be recorded in terms of the code. Section 9 is instructive. That is not only requires that the advice be recorded, it refers to products considered. And let me just quickly go to Section 9 of the General Code of Conduct. And like we said, this first module is setting the scene. So it's also a refresher of some of the compliance that we need to adhere to. Now, Section 9 or Paragraph 9 tells us, and the heading reads, record of advice. And it stipulates a provider, that's me and you, must maintain a record of the advice furnished to a client as contemplated in Section 8. And what did Section 8 say? About the risk profiling, about the knowledge of the client. That's what Section 8 said, about the needs of the client, about the objectives of the client. That must all be in this record of advice. So which record must reflect the basis on which the advice was given. So does your records reflect on which basis the advice was given? And just remember, if you do not have something on the risk profiling, how you did the risk profiling and how you got to this investment mix or this investment product that you're suggesting, how will you indicate to the FICE Ombud that it was suitable? And then in summary, the information and material on which the advice was based. So that's all very important when you're making this decision, is recording it. And actually the General of Code of Conduct tells us to record that in section or paragraph 9. Then the Vice Ombud also said that there is no indication that the complainants were experienced investors with a proper understanding of market fluctuation. So there was nothing on record. And when the Vice Ombud asked the clients, they established that these clients did not understand investments. They did not understand market fluctuations. On the contrary, complainants were cautious and sought out respondents' advice because they thought this guy, this person specializes, and they said specifically in unit trust. So we must be really careful when we look at this to take it into account. Then the last from this Vice Ombud determination that I would like to highlight is the Vice Ombud also alluding to section 31A3. Section 31A3 of the General Code said requires that the representations to the client be adequate and appropriate in circumstances when seen against the knowledge of the client. And section 71C requires that these representations provide full and appropriate information as to any material investment or other risk associated with the product. So you see here, when we go back to what we said earlier, when we send this plan or when we discuss this plan with our clients, are we making sure that this presentation or representation or report, that meets the knowledge of the client, that we, in simple, unambiguous language, describe to the client why this is suitable for them and why this advice was chosen for them. And also, the second point, very important, is do we highlight the risk associated with this investment? Do we tell the client, all right, you're 67 or 70 years of age, we're investing you in high equity. This is the reasons why we think that with this investment, in this case, that it's not important. So did we look at your risk capacity? Yes, you can take risk because you've got the capacity. Did we look at risk required? And yes, you've got a high tolerance. Just remember that somebody with a high tolerance for risk, it's not the okay for you then to invest that client in high risk or high equity investments. If that client does not have the risk capacity, or maybe the client don't need or does not have to, don't have a high risk required, then you don't have to invest the client in high capacity. So you need to look at all the factors. Interesting thing from the determination before I jump to the last one. It is, and this is what the Ombud said, it is to ensure that clients are provided with appropriate advice and to prevent unpleasant surprises. A risk profiler on its own can never be the sole determinator of a client's risk profile. So although the 3 legs of risk profiling is crucial and must be there, I think it's also important what the Vice Ombud alluded to here, where they said that you need to take the other factors into consideration, like the information of the client, like the knowledge of the client, like the objectives of the client. You need to marry that in your advice, in your plan, so that you assure at the end that this product or the advice given, that it's suitable to the client. All right, let's jump to the last. We've covered that slide. So let's look at the last Vice Ombud determination and this slide and the next slide, and then we're done for the day. This determination, Lombard versus Pioneer Financial Planning. Again, you see on the slides in front of you suitability. risk profiling and risk profile, establishing that helps with the suitability of the advice and the product at the end that you advise. So in this, and just to give you some facts on this determination, some background on it, in this determination, they invested the clients what they call UCIS, unregulated collective investment schemes, such as, and I've not even heard of these names before, Brando, Glenmore, and these were considered high risk and speculative investments. And they've invested their clients into this. Uh, the client was 57 years at the age of investing them. And you know what was concerning to me is when I read through the facts, and it was clearly stipulated in the complaint that the possibility of re-employment became increasingly slim for this complainant. And he said he wanted to ensure that the funds he had saved to date would be sufficient to sustain him and his wife when he retired in 2011. So that's background. The client said the possibility of re-employment is increasingly slim. And also said that, you know what, I need to ensure that the funds I've saved to date would be sufficient to sustain me and my wife till when she retired in 2011. So my question is, are we so complying? Are we so almost ticking the boxes of compliance that we do not listen to our clients, that we do not get these background and include that in the decisions that we make to advise them on? Then secondly, the investment value depreciated then substantially over time during this period from the investment to 2011. And the complaint was lodged in July 2013. So much that the value was less than 50% of the initial investment. And that's not linking to what the client wanted and that the client asked for this client. So why we've taken this determination out as one of those to discuss with you was specifically the importance of the record of advice and the risk profiling assessment. And in this determination, it was highlighted by the Vice Ombud that there were two critical documents that's central to risk record of advice and your risk profiling. And that's in terms of Section 9 that we've covered earlier, the record of advice, and then your risk profile assessment. So what Wessel is suggesting to make sure, continuing from here forward, that you understand what is risk profile, what it means, the risk capacity, the risk tolerance, and the risk required. That you understand how to get to an answer where you can advise the client to invest suitably in a product. But that's only one of the areas linking up to your advice. But most importantly is the second document, your record of advice, that you record everything, that you record the information, the data, the needs of the client, the knowledge of the client, like that you record everything and that you link that to the risk profile and to the advice and to the product that you've advised the client on. Then also what is very important is the record of advice. Before I jump to the last slide. The record of advice in this case was a 4-page document. And the Vice Ombud said, upon perusal, it immediately becomes clear that the document lacked vital information, such as the complainant's assets and liabilities, income and expenditure, and other relevant personal information that would have enabled the respondent to better appreciate complainant's capacity and tolerance for risk. People, it's so clear. Record of advice is a 4-page document, but that record of advice did not contain things like vital information about the client, background information, assets and liabilities, the objectives, the income. So certain of the elements to establish risk capacity, certain elements to establish risk requirement or risk required was not even in the documents that will need to clear you or me when there's a complaint laid against us. And let me then start to conclude. The Vice Ombud said, notwithstanding the information gathered by the means of the risk profiling assessment, the respondent still went and invested the complainant's retirement savings in an investment he knew nothing about, while persuading complainant that the investments were in fact low risk. So there was no connection between the record of advice, between the risk profiling done, and at the advice at the end. And then the Vice Ombud, and then I end where we started. The advisor failed to conduct his due diligence on the said investment. And that's in contravention of Section 2 of the Code. Secondly, having failed to conduct due diligence, the respondent did not disclose his lack of knowledge to the complainant about these products, instead advising complainant that the investment is safe, prompting additional contributions from the complainant. And then, so at the end, this advisor also did not meet with Section 81D, risk profiling. So this concludes today's session, and this is an introduction to the other three modules, telling us why it's so important to understand what is risk profiling, what you need to do also to make sure that the advice you give to your clients, that your record of advice, all aligned to make sure that you give suitable advice. So when there's a complaint laid against you, that there's a record of that, and that there can be a clear line between your advice, the background of your client, the knowledge of the client, the risk profiling of the client, and the objectives of your client, and why it's a suitable product. Peter, thank you so much. Thank you so much for everybody that joined. We've run 3 minutes over time. And again, really apologize for starting late, but hopefully you found this session valuable. Peter?
Wessel, yes, thank you very, very much, and for sort of speeding up your presentation. I don't think you left anything out. A lot of interesting questions, though, have been posed. Hopefully, people have got a bit of time. So if we just set aside another 5 minutes, if that's
I don't
okay,
mind,
just
Peter.
and we can address these questions jointly. So there was a question posed, I think, by Sean. Client risk tolerance may be low, but prudent advice and risk assessment may contradict this. What is the precedence that should be followed? I did address that, but I will be covering this in a lot of detail. So essentially, the 4 modules, this is an introduction that's merely stressing the importance of having a credible risk profiling process and the record of advice and the things you need to take into account when giving advice. Next module also talks about that. We talk about how we sort of weave the dictates of COFI and TCF into the advice process. And then I start talking more practical things about how to determine a risk profile, and taking what the generalities that Wessel has outlined and bringing that more to life, and how people would deploy these processes in their advice process and in their practices. Unfortunately, regulators are very good at laying down the law. And I mean, for example, in the Code of Conduct, Section 81C, I think it is, they just mention 2 words, risk profile. But nowhere do they actually define it. And hence, we as an industry then had to put our collective heads together and come up with some kind of a definition that could then stand up to the highest level of scrutiny. Fortunately, that lofty ideal and objective was achieved, and we put out the white paper, and through the phase on, but actually incorporating these principles in the determinations that Wessel referred to, that's pretty much now law. So if anyone tells you to do a risk profile in any other way, apart from what we're going to be conveying to you over the next couple of weeks, then you do so at your own risk. So just a note of caution there. Most providers are not equipped to have a slew of due diligences on their offerings by the advisor community. Good comment. And we'll cover that in a lot of detail in Module 3. We'll be having Marius Killian from 2IP. They are independent discretionary fund managers, and their sole purpose in life is to do research, do due diligences, both quantitative and qualitative, and assist advisors in putting together portfolios that then are able to achieve the client outcomes as determined in a proper risk profiling process. Just going back, risk profiling, tolerance, that's the psychometric side of things, needs and objectives, how much money have you got, what's your life expectancy like, what kind of capital drawdowns are you anticipating, how long do we need the money to last for, and then capacity. And capacity for risk is one thing, and if you're looking at it from the personality point of view, but capacity is also dictated largely by means. In other words, how much money have you got? Can we afford to take the risk that you need to take in order to make the money last for as long as your life expectancy? There are so many things that need to be addressed and articulated in the record of advice. Otherwise, you can be setting yourself up for attack by A, a client, and B, an arbitrator. Unfortunately, in this country, 90% of people just do not have enough money to retire on. So, they're looking for silver bullets from us advisors, and it's very difficult to give that. But as long as you've got a well-articulated record of advice, you can cover yourself. And it's not just a question of covering yourself. Building portfolios that match a client's risk profile, there's a lot of skill involved in being able to do that. So due diligence is one thing. Getting exposure to risk assets that align with the objectives as outlined and agreed on in the risk profile is the next trick. And also, do you go into top performing funds? Do you look for managers that are going to outperform the market, or do you look to just create an investment or put the client into an investment solution that is going to make the plan work? So we like to refer to that as being outcomes-based investing. And I think that's the way to go. That
Peter?
way, yes.
Peter, Wessel,
Yes,
yeah. If I may, just for the sake of everybody, and if you allow me just 1 minute, practical, and I know you will, and Marius will be getting to the practical side, but we are a small independent financial advice company, and we've got a house view. And I think by having a house view and having certain rules how you choose the funds that you will decide on, and we look at things like Morningstar and Fund House, and we look at the tier 1 funds and companies criteria like the fund must be at least 3 years or so. That mitigates your risk factors and doing due diligence, because the question asked as well is very difficult if you're a small independent company to do a lot of research on other companies and product providers. But what I see what happen is sometimes that people do advice on too many companies, on too many investment products. And I think by having a structured house view and a structure, how do you select your funds with certain criteria and using other people's research help a lot to mitigate the due diligence factor and the risk with that.
Thanks for that, Wessel. A lot of it goes around the value proposition. And if you ask advisors, what is your value proposition? There are not too many that can actually answer the question. And it's fundamental to the relationship and the service level agreement that ultimately you agree on with your client. I see the last question, Sean. You said, I find an explicit reluctance by advisors to review previous ROA, record of advice, or profilers. This is also outlined and agreed upon in your service level agreement, but I think it's also incumbent upon us as advisors and chat to your compliance officers. You need to do client reviews on a regular basis. And if it means reviewing the record of advice, if it means reviewing the retirement plan, if it means reviewing any component of the advice that you gave a year or 2 years before, it has to be done. So we're in a changing environment right now as financial advisors. We're in an industry that was formulated by the product providers. And the product providers built the industry, and I guess we've got a lot to be thankful for. But there's a worldwide move away from product-driven to advice-driven. So the burden of responsibility is now starting to sit squarely on our shoulders as financial advisors. And we have to make sure that the advice we give is in line with clients' needs, objectives, tolerance, capacity, and that we link them to solutions that make the plans work. It's a massive, massive responsibility. And unless you have a credible process, I'm just going along with what Wessel's been saying. These are all disturbing tactics, but it's the reality. So if you can just be patient over the next coming 3 weeks when we do modules 2, 3, and 4, I think we'll address all of these questions in a lot of detail. If it's okay with you now, I think there are people that would like to do the assessment before they forget what they've heard. So what I'm going to do now is close the presentation and open the assessment, and there will be a time limit of 15 minutes. So we'll be back with you next week. I see Jade is typing just before we go. Let's wait for these messages to come through. These are just thank yous. Okay, thank you, guys. So I'm going to close the presentation, but don't go anywhere because then I'm going to open up the assessment.